Hi, Tim Blankenship here at divorce661.com. In this video, we're talking a little bit about procedure and when you file your paperwork with the court. So most people come to us before they've ever started the process, but we do get a lot of folks that come to us at some point in the middle of their divorce process. Maybe they filed, they served, they did some disclosures, and then they get hung up at some point and they'll call us for help and we'll pick up where they left off, and that's no problem. We do that all the time. What we see a lot when people do start their own divorce is they will file what's called their property disclosures or declarations. I'm referring to the FL 160s. And we tell folks, when you're filing for divorce, when you're going through this process, I know you don't understand the process. Someone's telling you how to do this, or you read something online, or maybe you went to a clinic of sorts, and they'll tell you to fill out the FL 160s. We're telling our clients, if you're watching this, and you're not our client obviously, not to use the FL 160s when filing your petition for divorce. You can always do your property declarations later. The issue becomes when you attach your FL 160, your list of assets and debts, to your petition, and you file that and you serve it, and then you get to the judgment phase. If you come to an agreement other than what you disclosed or how you drafted your property declarations, the FL 160s, you have to dispose of all those assets and debts, likely exactly as you proposed on your petition. So if you are going to come to an agreement with your spouse, there's no need to attach the disclosures, or the declarations rather, to your FL 160, because it allows you, when you go to come to an agreement with your spouse, you get to make those decisions as you see fit. So for an example, with our clients, when we file the petition where it says list the separate and community property, we don't list any assets and debts. We simply say something like to be amended or to be determined at a later time, but we're not listing any assets and debts there, and we're definitely not attaching the FL 160s. If your case becomes as a default case, you can always amend the petition and then attach your FL 160s. That's the better way to go. So for our clients, we don't list any assets or debts on the petition itself. All of the agreements, the division of assets and debts, will come on the actual settlement agreement, and that will supersede anything that's been put in the petition itself. So you don't have to worry about listing your property on the petition when you file for divorce in California. Tim Blankenship, divorce661.com. Hope you're having a great day. Thanks so much for watching. Take care.